So moving on with the Marine Surveying Fest edition 2 for commercial ship surveyors. We are now at, where are we, 9 o'clock in the UK. Delighted to welcome online Mruali Pany, who's just admitted that this is his first time at trying this sort of presentation. So good luck with talking to your laptop, because I know it's quite challenging. I had the pleasure of meeting Mruali earlier this year in Singapore when we held a one-day conference out there for RMS members. And I was much impressed with the content of his presentation, and hence why I've invited him to contribute to the fest today. So Mruali is managing partner of Joseph Tan Jude Benny Lawyers, who are based in Singapore. And the subject of his presentation is a collision case study, implications for surveyors, and then something on IMO 2020 with some potential opportunities for surveyors. So without further ado, Mruali, over to you.
Thank you very much, Mike. Yes, indeed, my very first time doing something like this. So even old dogs can learn new tricks. Right, I won't spend too much time. So greetings to everyone who's logged in. And thank you for the opportunity from the association to allow me to speak at this event. I won't spend too much time on the first two seminars. That's just a little bit of information about my firm. And that's a very old picture of me. Don't look like that at all anymore. And I'm the managing partner of this firm. Now, moving on to the topics proper. As Mike mentioned, there's two subtopics in my presentation. One is a collision case study involving a vessel called the Napa 1, which went to the High Court here. And of course, the very soon upcoming IMO 2020 global sulfur cap. And I'm approaching this topic because I think it has been spoken of to death. I'm approaching this topic from the defense to breach angle, which also provides opportunities to surveyors. Starting with the Napa 1. Now, this was quite an interesting case. The Napa 1 was the vessel that was collided into, and in this case, we acted for the owners. The case, unfortunately for us and the owners, didn't go too well for them, and there were very specific factual reasons that were peculiar to the case that resulted in this sort of negative outcome. But why I want to speak about it is because there are other aspects of the case which give rise to principles and issues of general importance, which I think are quite useful for those in the maritime industry and anyone involved in casualties to know about. So in this case, the Napa 1, as I said, was the vessel that was hit, and the opposing party, the defendant, had agreed to bear 100% liability for the collision. So the dispute in the end was entirely on the quantum of the damages. And the case went to court to assess quantum of damages. And I think one principle that really comes up in this case is the perils of taking the path of least resistance, as you will see as I take you through my presentation. Now, these are the facts which are relevant to the principles of general importance. The vessel called at Singapore, and it was anchored in the eastern outside port limits on the 23rd of December 2011. And she came into port for her annual class survey. The class survey was carried out, and the surveyors made 12 class recommendations. Now, according to the owners, after the survey, they were busy carrying out various repairs, including repairs to implement the class recommendations. But on the 27th of January, that was when the collision occurred. Now, the plaintiff's vessel, is worth mentioning, was a crude oil tanker, small tanker, and the collision caused damage to the shell plating and internals of the forepeak tank. There was a rupture to the hull, but above the waterline. So after the collision, on the 2nd of February 2012, surveys were conducted by a collision damage survey. In the course of this survey, it was discovered that there was also other damage, pre-existing damage, that was not linked to the collision. Now, on the 3rd of February, the plaintiffs had finished the tank cleaning of the vessel, and on the 4th, set sail for a shipyard in Batam, Indonesia, to carry out repairs. And they, in this shipyard, they carried out all the repairs. They carried out the collision damage repairs as well as the class repairs and the pre-existing damage as well. The repairs were completed on the 19th of March, and the vessel was surveyed and class was implemented again on the 22nd of March 2012. So those are the background facts that are relevant. As I mentioned, there were 3 aspects of repairs that needed to be done. Pre-existing damage, just for information, related to the bulbous bow plate. So these were the repair costs that were claimed by the plaintiffs. Right? Now, the first thing you will note is that the biggest item of cost was the tank cleaning services. Right? That was a huge, almost 80% of the claim, $280,000. And the collision damage costs were actually a very small proportion, $31,000 only. And another big element of another portion of the cost was general services. Now, do bear in mind that during this time, as I mentioned, owners were also doing other repairs unrelated to the collision. So naturally, when the case went to court for assessment, the defendants raised a number of objections, and the main objection pertained to the tank cleaning. Now, the plaintiffs took the position that, as it was the innocent party, the plaintiff was entitled to go to the shipyard for collision repairs, and it took a position that it had to go to the shipyard for the collision repairs because there was a rupture in the hull. And because they had to go to the shipyard, they had to clean the tanks. The defendants argued that the collision damage could have been done afloat at an anchorage rather than at a shipyard. Now, the defendants also made 2 other points in the course of this, hearing. They argued that the plaintiffs did not exercise any evaluation. By that I mean the plaintiffs chose to go to the shipyard immediately without considering alternatives or getting quotes for alternative shipyards or other courses of action. And they raised the point that the plaintiff's decision to carry out the cleaning of the tanks was unrelated to the collision because they needed to go to the shipyard for their own repairs. There were experts involved in this case on both sides, and as in the case of any case where experts are involved, both experts had diagrammatically opposite views. The plaintiff's expert, of course, took the view that it was a requirement in Singapore and indeed in Batam, before a ship could enter into a shipyard for repairs, the vessel had to be tank cleaned, the entire vessel and all her tanks. The defendant's expert took the position that the collision damage could have been repaired afloat, so it was not necessary to proceed to the shipyard, and hence not necessary to clean all the tanks. It would have been sufficient to clean the tanks that were closest to the area affected by the collision. Now, before we go to what the court decided in this case, it'd be useful to have some information on some general principles related to the law on recovery of damages. So the first principle is the normal measure of damage. That means the innocent party can recover the repair cost, which is considered direct loss, and can also recover the amount by which the value of the vessel has been diminished. So if, for example, after the repairs, the vessel is worth less than what it was before, that reduction in value is also recoverable. Of course, a question will arise in most people's mind: what if the vessel after repairs is worth more than what it was before the incident, is the innocent party, the plaintiff usually, obliged to give credit for the increase in value? The law provides that that is not the case. The innocent party is entitled to keep any increase in the value of the vessel after repairs are done. The second principle is that the law also allows recovery for what they call consequential costs or damages. So these are all ancillary to the cost of the repairs. They include, I put a list here: docking expenses, tugs, tank cleaning, which is the main issue in this case, inspection fees, superintendent fees, and cost of bunkers during the needed for or consumed during the repairs if they were necessary at that time. It's also possible in the case of a ship that is under employment to recover the cost of a substitute ship to fulfill a contract. So these are all basically the costs that can be recovered. However, there is a principle that also comes into play called the principle of duty of mitigation. This means that the innocent party cannot simply hope to pile all the losses onto the defendant without any thought or consideration. The innocent party will be obliged to take steps to reduce the cost, reduce it in acting reasonably. So the plaintiff is required to act reasonably, and he's not required to go above and beyond the call of duty to make life easier for the defendant, but he is obliged to act reasonably and take steps to reduce the loss that he has suffered. To put it another way, the innocent party can incur as much as he likes in terms of repair costs, but he's only entitled to recover what is reasonable. It's said quite nicely in this case of Theodore Walter. It says, in short, he is fully entitled to be extravagant as he pleases, but not at the expense of the defendant. So there we are. That's really the principles that apply to recovery loss. You have a case where the innocent party is entitled to recover all direct and indirect loss that he has suffered, but at the same time, he is obliged to take steps, reasonable steps, to minimize the loss. Now, it'll be useful actually at this time to also consider an ancillary principle that applies here, which is what happens in a case where the ship owner takes the opportunity to carry out non-casualty related repairs during the time casualty repairs are being carried out. So concurrent repairs, in other words. The principle is that if the innocent party, as a result of the casualty, had to go into the shipyard because of the nature of the casualty damage and the seriousness of it, then that innocent party is entitled to carry out incidental repairs at the same time, and the only reduction in the cost of the repairs will be those costs directly attributable to the incidental repairs. So all the other general costs, tank cleaning, tugs, dock charges, all that will be claimable if the primary cause of going to the shipyard was the collision repairs. The converse applies if the non-casualty repairs was the prevailing factor or the key factor in causing the owner to go to the shipyard. If that's the case, then the owner can't take advantage of a casualty that occurred and try to lump all the costs on the defendant. In such a case, the owner is only entitled to recover direct casualty-related costs. So that's the law on incidental repairs carried out during casualty repairs. So coming back to the Napa one. what did the court hold in this case? As I said, it was not a good result for the owners. The court ruled in favor of the defendants and decided not to uphold the plaintiff's claim for cost of the tank cleaning services. The court felt that it was not necessary nor reasonable for the plaintiffs to clean the vessel tanks to repair the collision damage. In fact, the court agreed with the defendant's expert and said that it was possible to carry out the collision damage, repairs to the collision damage while afloat. And so if it's not necessary to go to the shipyard, there was no need to clean all the cargo tanks. The court also stated that the plaintiffs had not considered the availability of other viable alternatives for repairing the collision damage. Now, this was indeed the case because the ship owners and their managers took a very simplistic view. They took a view, I was hit, there's a rupture, I need to go to the shipyard, and I'm entitled to go to the shipyard. And they took that very straight line path of least resistance and sent the vessel to the shipyard immediately without considering any other options. And that was what really turned the case against them. Equally, they had no documentation to substantiate the fact that they considered these options and decided to go to the shipyard for the collision damage. So I think apart from the fact of, or rather the need for owners or managers to consider other repair options, this case also highlighted the importance of having documentation to support any decision that's made, to support an analysis of the options and in relation to the type of damage and the decision that's reached as a result of it. So it goes back to the point that I made. In the case of any casualty or any damage, it is always dangerous to take the path of the least resistance. And in the light of this case, particularly in Singapore, I think any owner or manager in deciding a course of action to take must consider other options and not take what seems to be the usual or tried and tested path. Now, I think, just to sum up on this point, it is also necessary to consider a question of proportionality. Now, if you note that in the total repair cost, which came to about $350,000, the collision repairs was only $31,000. So the court also looked at it and felt that it was very disproportionate for the plaintiffs to incur such a high tank cleaning cost when the repairs that were needed for the collision damage were very low indeed. Now, this was despite the fact that we argued that carrying out collision damage repairs afloat was far more risky than going to the shipyard. That in carrying out a float in anchorage, expose the vessel to the weather, expose the vessel to the vagaries of tide. The crew were working in far more dangerous situations because they're working in open waters off the side of the vessel. The fact that additional insurance would be required, that there was no easy access to firefighting or safety equipment or medical equipment, and doing repairs afloat put the entire burden of the vessel's safety during the repairs on the owners, whereas in a shipyard, the safety of the vessel shifts to an extent to the shipyard to look after whilst the vessel is there. None of that cut any ice, and simply the court took the view that it was not proportionate and the plaintiffs were not able to demonstrate that they had considered other options and made a considered decision to choose repairs in the shipyard. So, moving forward, what is the advice to owners? Well, as I meant, not to spend money on the assumption of recovery and not to immediately choose the easiest path of going to the shipyard. They have to consider alternative methods and options and costs and the proportionality of that cost to the damage in question, make a considered decision, and most importantly, keep documents and records of the decisions they make. Now, insofar as surveyors are concerned, surveyors are usually first on the scene for any casualty. Lawyers come in much later, after all the dust is settled. Then we come in to argue on questions of law. But the surveyors are there factually first in the scene, and this is where I think owners do need this guidance. So owners and managers do need this guidance about how they should be considering what sort of repairs to take. And this sort of guidance and advice can come from surveyors. I think they're ideally placed to do it, and equally ideally placed to make sure documentation is in place and evidence is secured to support a decision for a particular course of repair. So that's the end of the Napa 1 case study. Hope you found something useful there. The next topic that I'm going to speak about is the much spoken about global sulfur cap, which is literally, I think, about 19 days away. But I'm approaching it from a different context, as I said. I'm approaching it from considering how to prevent or rather mitigate the effect of breach. And again, another opportunity for surveyors, again, as the people on the front line. Now, I think we all know by now what the sulfur cap consists of. This is a short summary of it. In short, globally, not excluding the ECA, the exclusion emission control areas, from the 1st of January, vessels will not be able to burn fuel having more than 0.5% sulfur. And from the 1st of March, they won't be allowed to carry such fuel for the purpose of propulsion. Carrying it as cargo is fine, but not for the purpose of burning. And the penalties. Now, in Singapore, the penalties for breach of the global sulfur cap is for each offense, there's a fine of $10,000 or imprisonment for a term not exceeding 2 years or both. Now, imprisonment will be imprisonment of the owner or the master of the ship. Now, I think you can see from this that a fine of $10,000 is not really very much. And I've had some remarks from some owners who said it's much easier for them to pay off the fine. Imprisonment, I don't think is going to be an approach that's taken by the authorities here. It's really no point having a host of masters languishing in jail and the port clogged up with vessels that can't move. Owners very often are not within the jurisdiction. So it's not going to be an effective means of enforcing the sulfur cap. The more effective means is the other powers provided by the Act, which is to either deny entry of a ship to port or to detain the ship. And in the course of various conferences here, the indication from the MPA is that at some point it's going to be detention, because the economic consequences of a detention are far heavier than the fine, because the vessel will have to then take steps to become compliant before she can leave. So that means offloading the non-off-spec cargo, cleaning the tanks, and loading conforming cargo, compliant cargo, loading compliant fuel. So that in itself is a huge cost. On top of that, you have the delay of the vessel. If she's under employment, is going to expose the owners to claims for delay of delivery of cargo. So this is going to be, I think, the effective mechanism. And my view is going to be utilized in the form of an example. So at some point, somewhere, the MPA the Maritime Port Authority in Singapore has really indicated that they are not going to take an impractical approach or a very rigid approach. There's going to be some flexibility in the early parts of 2020. And they're going to be monitoring, but they're going to be monitoring compliance. I personally believe there's going to be monitoring, there's going to be notifications, advisories, or warnings. But at some point, there's going to be the big example that's made of some ship owner where the vessel's going to get detained and with all the consequences. So that's going to be, I think, the strongest tool the threat of this tool or this punishment is going to be the strongest one to encourage compliance with the sulfur cap. Now, there are a number of ways to comply with the sulfur cap. I have them here, but the point to be made is that on scrubbers, right? Scrubbers actually involve the use of non-compliant fuel. The scrubber simply cleans the emissions to make it compliant. Now, the scrubber is allowed because it's an exemption under MARPOL. It's a regulation 4, I think, which allows alternative methods to comply with the 0.5% emission standard. We have a number of uncertainties relating to how these sulfur cap regulations are going to play out. Firstly, if you look at the regulations and the MARPOL and indeed the local legislation in Singapore, there is no grace period, right? So the moment you're in breach, or the moment your fuel is non-compliant, you are, according to the statute, considered to be in breach. There's uncertainty about different application of this, the rules in different jurisdictions, in particular strictness of enforcement and the penalties. And the provisions currently for this new are untested by the court. So nobody knows if indeed when a breach does occur, how is the court going to deal with it? Now, it's worthwhile to note that the IMO philosophy for the sulfur cap is strict compliance, and also a principle of non-discrimination and no more favorable treatment. So what IMO wants is consistent application across jurisdictions and strict enforcement. So here we are. We have a situation where the legislation itself takes a very strict approach, but practical implementation might require a slightly more flexible approach. And that is indeed the approach that's being taken by the port authorities in Singapore. The MPA has published a number of guidelines which indicate that they will be practical, and certain events, like when a ship cannot, when for example, if the scrubbers break down, the MPA here will not consider the ship as being in immediate breach of the regulations. So a slightly more practical approach, even though not quite in line with the legislation itself. Now the question is, that I want to focus on is, what can owners do if there is a breach? Now, a breach can occur in a number of different ways. It can occur when an owner takes on non-compliant fuel. It can occur if there's a breakdown in the scrubbers. It can occur if the fuel itself subsequently it's compliant on take-up, but later on the fuel, because of blending or because of its inherent properties, becomes non-compliant. Or simply if compliant fuel is not available at a particular port. Various scenarios where owners can end up being in breach. Two main clauses, or two main regulations come into play in a situation where owners are in breach. Now, the first one is Regulation 3. It provides a defense to a breach of the sulfur cap where emissions have exceeded the stated limits. What is relevant to us, I think, in the context of commercial operation is that it is a defense if the emission results from damage to a ship or its equipment, provided, there's a proviso here, that all reasonable precautions have been taken after the occurrence of the damage or discovery of the emission for the purpose of preventing or minimizing the emission. Now, again, there are question marks about this defense because it talks about, firstly, reasonable precautions, but no guidelines have been provided for reasonable precautions. So what constitutes reasonable precautions? And the first part of that, of paragraph B, it says any emission resulting from damage to a ship or its equipment. Now, when we talk about damage to a ship, legally in this clause, this normally refers to where some external event has caused damage to a ship, and this has resulted in some way or other, the breaching of the sulfur cap. It doesn't cover the situation of inherent defect. So this clause would not cover a situation where scrubbers break down due to a technical or manufacturing defect, because that is not damage to a ship or its equipment. There's no external force that's coming into play here, but rather an inherent vice. So while if the scrubbers fail due to a manufacturing defect or poor maintenance, there isn't a defense to a breach of the sulfur cap, though there may be a claim against the scrubber manufacturer. But nonetheless, this clause, this regulation, does provide an avenue for owners to look at in order to defend a charge for breaching the sulfur cap. But what they will have to show in order to take advantage of this defense is the taking of all reasonable precautions. The other regulation that applies is Regulation 18. Now, this regulation confers a discretion on a particular, every jurisdiction to consider whether or not to take action in a particular case. So if there's no compliant fuel on board and the master uses non-compliant fuel, breach of MARPOL, right? Now, in the case of unavailable fuel, the regulations also provide for the master to submit a non-availability of compliant fuel form, or a FONA form. Now, you will recall from the earlier extract from the MPA Guidelines that what the MPA has said is that you're not going to be in immediate breach, but the FONA form should not be construed as a get out of jail card. It simply is a notification, and it is one of the things that will be considered in determining whether that particular breach is something that should be, the action should be taken against. Now, you will see from the subparagraph to this regulation, again, what is required is a very high level of due diligence, because in order to prevail upon the regulatory authorities to not take action, the ship has to show that it has taken steps and best efforts to get the fuel, but no such fuel was available. To this, the vessel has to show a record of actions taken to attempt compliance. It must show the purchasing efforts. It must show that fuel was simply not available. Compliant fuel was not available at that time when it was in port. Having fulfilled these standards, it then may prevail upon the authority of the country, of the port in question, not to pursue the vessel, the owner or the master, for a breach of MARPOL. So, both defenses have one common factor. They both require a high level of due diligence, right? Whether in terms of getting non-compliant fuel or operational breaches of MARPOL, high levels of due diligence are required in order for ship owners to be able to invoke the defenses. So this really means, to put it very bluntly, an owner who, for example, uses scrubbers has to show a proper purchase of scrubbers, proper training, proper maintenance and operation, and all these things have to be properly documented. There's got to be fuel management plans and protocols for the use of fuel and taking on fuel. There's got to be protocols for looking to make sure compliant fuel is available in the port of call. documentation, protocols all comprise due diligence. And so I feel that this is where there's another opportunity for surveyors to help owners and managers and operators to review, verify, and even audit their 2020 due diligence chain. This gives them at least a chance, in the case there's a breach, to invoke the defenses that are available. That really brings me to the end of my presentation. I think I finished on time.
Mruali, you've done very well on time. All spot on, thank you. So, I'm happy to take any questions for Mruali. If anybody wants to bounce in. If not, I have just a general point, really. I mean, where do you think, Mruali, we are at with IMO 2020? What's the current what's your thinking on all of this as you said, within 19 days now?
I think from my interaction with the owners and the industry, the choice of scrubbers is not that widespread. Most owners are going for compliant fuel, and they are aware of and prepared for the increased cost of that fuel. The next question is, how are they going to pass that cost on, or at least some of it on down the line? So having said that, so having the majority of owners and operators, I mean, I'm talking about the big boys, going for compliant fuel, the question becomes one of, will the new set of compliant fuels be up to the mark, which nobody knows yet.
Is there sufficient supply of those fuels?
Based on the information, yes, there is sufficient supply, certainly at the major ports. The question really is, how is that fuel going to hold up to operation? Because they've all been blended or refined to achieve the new emission level. And some of the concerns are that we don't know whether the fuels, the acids, or the properties will hold up or will break down and cause damage to the engines. So one big fear is not really breaching MARPOL, but using compliant fuel that leads to engine damage. They issue concerns about viscosity and things like that. And that's where the concern lies now.
So
the other part of it is scrubbers, because nobody is really sure whether scrubbers will hold up because they've not been designed to work 24/7.
Yeah. So do you share my concern that we might find dozens and dozens of vessels impounded in ports around the world, or is that just not going to happen?
I don't think we will see that. I think there'll definitely be breaches, right? If a sensible approach is taken, it will be to give the industry some time operationally, not legally, because everybody knows about the sulfur cap coming up. Now here we are running the race. It will be a sensible approach to give everybody a bit of time, give notices, advisories, warnings. So a vessel in breach can be monitored to see that it's not going to continue breaching. But I don't think we should see, certainly not outside the ECA zones, vessels being impounded and all being cluttering out the port. I don't think so. And that certainly is not the preference of the MPA, because we can't afford to have vessels cluttering up our ports.
Well, it's in no one's interest for that to happen. I suppose this is a personal question, or for my own personal interest, really. Ultimately, does the consumer in various countries around the world end up paying more for their goods because of all of this?
Well, traditionally, it's always been the consumer that's taken the knife. I think it'll have to be, really. Owners have to pass it down somewhere.
They do.
We'll go down the chain.
Yeah, they do. They do. Mruali, thank you very much, and thank you for persevering with this new technology, which I know is all very strange to you. But you've handled it fantastically well. So I hope we can encourage you to come on and speak at another time. So much appreciated.
Thank you so much, Mike.
Thank you very much for joining us, and we'll be in touch with you soon.